And up to bat to lead off the bottom half of the first inning is the Cincinnati Reds second baseman, Maury Rath. Rath has had a quality year after missing the previous season while serving in the Navy, having a .264 batting average through the season. And the first pitch from Cicotte is in for a strike. Eddie Cicotte this year has been tremendous, leading the American League in wins, innings pitched, and winning percentage. The White Sox will rely heavily on his pitching in this World Series. And the second pitch, he hit him! Cicotte's second pitch was a wild one and hit Maury Rath right in the back. My goodness, what an unexpected start to the game from the normally reliable Cicotte. White Sox fans will surely hope this isn't a bad omen for their team in this World Series.
The national pastime of baseball is a living, breathing, sacrosanct being for many ardent fans, and it was even more so in the 1920s when today's innumerable distractions didn't exist. So prominent was baseball's place in American culture at the time that news of the cheating scandal from the October 1919 World Series between the Chicago White Sox and the Cincinnati Reds was on the front page of every newspaper in the country. The phrase, "Say it ain't so, Joe," first written in the Chicago Daily News, quickly became immortalized when another reporter either mistakenly or artistically attributed it to an innocent young child standing outside the courthouse.
As Jackson departed from the grand jury room, a small boy clutched at his sleeve and tagged along after him. "Say it ain't so, Joe," he pleaded. "Say it ain't so." "Yes, kid, I'm afraid it is," Jackson replied. "Well, I never would have thought it," the boy said.
Joe's response to the boy's plaintive plea confirmed our biggest fear. It was true. Before the trial started, the jurors knew what you know. Rumors of a fix, big-time gangsters and gamblers, players who were investigated by a grand jury, with 3 of them supposedly confessing, and grand jury indictments against the Black Sox and several of the gangster gamblers. As the story slowly unfolded, it became filled with all the colorful characters you'd expect from 1920s America. Baseball players with catchy nicknames, short-tempered gangsters/gamblers immaculately dressed in business pinstripe suits, newspaper reporters and radio broadcasters with flowery descriptions of the trial as if itself was a baseball game, and even New York mob boss Arnold Rothstein, who was alleged, but never proven, to be the impetus of the scandal. These characters all weave together to form the tapestry of this infamous story that broke America's belief in the purity and innocence of baseball. So, join us and grab a box of Cracker Jacks, a hot dog, and a beer as we look at the trial of the 1919 Chicago Black Sox.
They said to me, "This is going to be a long trial. You don't want your wife and babies to suffer while you're in the penitentiary, do you?"
One of the points to be made by the defense is that there is no law to force a ballplayer to play his best.
Austrian then shouted, "You need a lawyer damn bad."
Redmond engaged in an acrimonious debate with Attorney Berger, finally saying, "You won't come outside and talk like that to me."
Please pull up a chair and have a seat with me at the counsel table. You're going to sit right next to the lawyers while they cross-examine witnesses, fight off objections from opposing counsel, and deal with anxious defendants facing big fines, long jail terms, and even death sentences. You'll also have a front row seat in the jury box as you listen to the testimony straight from the witnesses. And then, after hearing the final verdict, you can decide whether the rulings were correct or not. Hi everyone, my name is J. Craig Williams, and welcome to In Dispute. In this podcast miniseries, we will look back at 10 famous court cases that stand out for their historical importance, their contrasts with today's modern criminal trials, and their unusual outcomes. Unfortunately, the Black Sox trial transcripts were lost long ago, requiring modern-day historians to rely on newspaper reports of trial testimony, which were sometimes sensationalized for their readers, and at other times directly contrary to one another. So, take the news reports and dialogue in this In Dispute episode with a grain of salt. Most of the reports quoted here come from stories filed for the major news services of the day by 2 or 3 main reporters. Numerous other reporters covered the story for smaller local papers, offering a slightly different take on the events. From this reality, admittedly many of the facts about the scandal we're about to examine are, true to the show's title, in dispute.
Breaking news from Chicago. Black Sox called to face indictment. 10 of 18 respond to court's order. Chicago, June 27, 1920. 10 of the 18 defendants in the baseball trial that opened here today put in an appearance. The White Sox players Felsch, Seacott, Williams, Jackson, Gandil, Weaver, and Risberg were on hand when the case was called. Fred McMullen, the other indicted player, is on the Pacific Coast, and his attorney stated that he would appear whenever the court ordered him to do so. He is under bond. With the 7 players in court appeared 3 other men, accused as gamblers: Ben Levi, Louis Levi, and David Seltzer. 2 other accused gamblers, Carl Zork and Ben Franklin of St. Louis, both of whom were also under bond, were not in court, but their attorneys presented affidavits to the effect that both were ill and asked for a continuance.
The case was filed on October 10, 1920, in the criminal court of Cook County, Illinois, and the 8 men out and the gamblers were arraigned months later on February 14, 1921. But even though conspiracy allegations started flying back and forth between the team's fans right after the end of the World Series more than a year earlier, the state's prosecution languished until June 1921. On the opening day of the trial, Judge Hugo Friend first overruled the defendant's motion to quash the prosecution's 5 conspiracy charges. Number 1, conspiracy to defraud the public. Number 2, conspiracy to defraud Raymond Cracker Schalk, the White Sox catcher, out of his World Series bonus. Number 3, conspiracy to commit a confidence game. Number 4, conspiracy to injure the business of the American League. And number 5, conspiracy to injure the business of Charles A. Comiskey, the White Sox team owner. The defense lawyers made the motion to dismiss the indictment on the grounds that the 5 conspiracies could not have been committed at the same time, but their motion was more for show than results. The standard style of charging crimes is known as alternative pleading, and the prosecution properly employed it here. With limited exceptions, the prosecutor, or plaintiff if it's a civil case, is allowed at the beginning of the case to argue different legal theories based on the same facts. But at the end of the case, this style of pleading requires the party to pick the applicable theory to allow the judge or the jury to reach a verdict. At the start of the trial on June 27, 1921, having worked out the technicalities of the pleadings, it was time to select the jury. Nearly 200 potential jurors were in the courtroom at any one time, out of a pool of some 600 waiting around the courthouse to be called and examined. Judge Friend granted each side an unbelievably high 120 challenges, which resulted in a 2-week stint to impanel the jury. As an example of today's limits, in California, each side may get just 10 challenges. During jury selection, it's common for both sides to try their case to the jurors before calling a witness and introducing evidence. The prosecution also attempted to taint the jurors' opinions of the players with stories of the players' late-night partying and carousing with loose women. Rather than respond to those allegations, however, defense attorney Benjamin Short ignored the boys' sex problems, instead comparing his baseball player clients to the beauties of a sultan's harem, meaning the team's owner, Charles Comiskey. After 2 weeks of jury questioning, the prosecution and defense had managed to select only 4 jurors, including a machinist who said he was a White Sox fan, but bet on the Reds because he thought they were the better team. Frustrated, the jury selection had virtually ground to a halt. Judge Friend ordered the parties to stay at the courthouse for night sessions on July 15th in order to speed up the process of impaneling a jury. The lawyers got the message and seated the final 4 jurors before the end of the day. The real question, however, was which side the jury would favor. According to news reports,
the jury is made up of 2 clerks, 2 machinists, a telephone repairman, a stationary engineer, the foreman of a motor company, a steel worker, a salesman, a florist, a hydraulic press operator, and the foreman of a stockyards rendering plant. All but 2 are married, and their ages range from 30 to 47. All said they understood baseball and occasionally saw major league games, but none ever played semi-professional or professional baseball, and none is a student of the game or of the fan type.
The defense succeeded in stacking the jury with jurors who best suited their theory of the case, which proffered 2 theories. First, that the players never intended to do anyone harm. and second, that the conspiracy was a fabrication of American League President Ban Johnson, designed to punish National League White Sox owner Charles Comiskey, nicknamed Commie and the Old Roman, as part of their rivalry. Over the weekend, the defense team was busy working on a motion to exclude from the testimony of the Black Sox trial the alleged confessions of Eddie Cicotte, Shoeless Joe Jackson, and Claude Williams to present to the judge on Monday. Knowing that the original signed confessions given before the grand jury proceedings were missing, the players' attorneys planned to keep the confessions from being entered into evidence by arguing that their statements were given without the benefit of their own attorneys, and that the players thought they were receiving deals of immunity instead of making confessions. In his ruling, Judge Friend denied their request to strike the confessions, but granted the defense attorneys' motions to interview the state's two-star witnesses out of the presence of the jury. Former Major League pitcher-turned-gambler-turned-state's witness, Sleepy Bill Burns, and Joe Gideon, who had also flipped. Both worked for Arnold Rothstein and were alleged to have key roles in the scandal. Initially, the defense thought the prosecution would not be able to produce these witnesses at the time of trial. Supposedly, gambler Arnold Rothstein and his attorney had arranged to send Sleepy Bill Burns to Mexico to hide from the process server. American League President Byron Bancroft Ban Johnson, by then an arch enemy of Comiskey, had an investigator track down Sleepy Bill in Mexico and convince him, well, let's correctly say pay, to return to testify against Comiskey's bad boys. Just before trial during jury selection, Burns showed up at the courthouse to turn state's evidence. The judge also required the interview to take place in the presence of the prosecutors. The interviews, however, went nowhere.
The Black Sox greeted Burns and Gideon cordially, all shaking hands. The two witnesses, who are to turn state's evidence, refused to talk, however, and failed to disclose the nature of their testimony when questioned by defense counsel. Burns, alleged to be one of the framers of the alleged conspiracy, gave the same answer to every question. "I do not care to discuss the case at all," the former Major League pitcher replied to every question. "I have nothing to say," was Gideon's stock reply, both men having been instructed by the state to give the same answers to every question.
The defense then made a motion to exclude their testimony based on their failure to respond, but that motion was inexplicably denied. When the trial started on Monday, the sparks began to fly even before the jury made it into the box. As AP correspondent Carl Victor Little colorfully described the events.
The Chicago Black Sox got to first base today when they made the initial hit in their trial. Umpire Hugo Friend, criminal court judge, ruled that State's Attorney Gorman must not mention that 3 of the Black Sox made confessions during his opening statement to the 12 scorekeepers in the jury bleachers. This followed arguments by attorney James Ropes O'Brien and other pinch hitters for the 7 former White Sox stars charged with conspiracy to throw the 1919 World Series with the Cincinnati Reds. Umpire Friend gave prosecutor Gorman permission to mention everything in the confession of Eddie Cicotte, Lefty Williams, and Shoeless Joe Jackson, but forbade him to let the scorekeepers know confessions had been made.
Judge Friend's decision split the baby, but favored the defendants a bit by excluding the pejorative word confessions from prosecutor Gorman's opening statement. The effect for the prosecution was virtually the same without that word, however, since the ballplayer's statements reeked of admissions. For the most part, the judge's ruling was a distinction without a difference. The defense lawyers were also going to make it a case of overinterpretation of the law. They were counting on their working man jury to sympathize with their clients and focus attention on the requirements of the players' contracts, or more particularly, their lack of contracts.
One of the biggest points to be made by the defense is that the players are not guilty of wrongdoing under the law. It will be emphasized that there is no law to compel a working man to work his best, or nothing on the statute books to force a ballplayer to play his best. The defense is also prepared to attempt to prove that the Black Sox were not under contract during the World Series, and therefore could do as they saw fit. The fact that these so-called masterminds who supposedly furnished the money have not been hauled into court is expected by the defense to have a reaction on the jury favorable to the Black Sox.
You might as well start with a bang with your first witness, or at least a fist fight. The old Roman, Charles Comiskey, came into the courtroom dressed in a top hat and tails, studiously avoiding looking at his players despite their attempts to make eye contact with him. Comiskey testified on direct without incident, dutifully covering the points of the fix and his players. But sparks flew on cross-examination by Benjamin Short, attorney for the Gamblers. He would pull no punches with old Roman, asking whether he was guilty of the same behavior as his former players were accused of.
Is it not true, Mr. Comiskey, the lawyer asked, that when you left the Cincinnati National League club, of which you had been first baseman and manager, you jumped your contract? Comiskey reddened. That is not true, the witness declared. Jumping from the chair and starting toward the attorney, he shook his fist in the face of Attorney Ben Short. The tall, striking-looking old gentleman with a shock of gray hair, who has been in baseball for 47 years and who now owns and operates one of the most magnificent ballparks in the major leagues, lost control of himself at a question that he took as a personal insult.
Other defense lawyers jumped up in feigned support to protect Short. Fans rose from their seats in the gallery, and the entire court went into an uproar. Judge Friend called for order and threatened to clear the courtroom. He then struck both the question and the answer from the record. After things settled down, the slightly calmer but still mad Comiskey insisted he did nothing wrong, while the defense attorney accused him of trying to ruin the ball players' careers. But the damage had been done to Comiskey. The defense had succeeded with the oldest lawyer's trick in the book: get the witness riled up. The state then called one of the World Series official scorers to prove that statistics didn't matter. This witness was their attempt to disprove a defense theory that the players' stats during the World Series were not distinguishable from their stats in the regular season. The state also called the Sox club secretary to the stand to testify about the players' salaries. If the state intended to start with a hit, no pun intended, then the players' salaries certainly did that, highlighting the disparity between the players and the jurors, who as blue-collar workers made much less than the boys. The trial continued on Tuesday, July 19, 1921, but the real trial was as much in the background as Al Spink, one of the witnesses from the first day, wrote in a column in the Reno Gazette.
Gamblers Hal Chase and Abe Attell, two of the black sheep and really the two leaders in the entire baseball conspiracy, are not in attendance at the trials of the Black Sox players. Chase was arrested in California and headed this way when smart attorneys secured his release from custody by habeas corpus proceedings. Attell, by the same method, secured his release in New York. Those were the two witnesses that the heads of organized baseball wanted to get on the stand worse than any two others, but they missed out on them.
Reportedly, William Fallon masterminded Attell's and Chase's release. Who is William Fallon? Well, he's the attorney for Arnold Rothstein, the New York mob boss, who allegedly financed the throwing of the World Series. Attorney Fallon did so to avoid further ties from the trial to Rothstein, because Attell was Rothstein's confidant. But even without these gambler witnesses, the state was on a roll, and next brought out its star witness, the former pitcher for the Sox and now a small-time gambler, Sleepy Bill Burns, who testified in exchange for immunity from prosecution. After establishing the basics of the plot to throw the World Series, the state's lawyers brought out the clincher. Burns admitted he helped frame the deal with which the Black Sox are alleged to have sold themselves out to the gamblers.
I met Eddie Seacott in New York. He told me the White Sox would win the pennant, and there was a plot to throw the series to the Cincinnati Reds if enough money could be raised.
Sleepy Bill Burns' testimony placed the genesis of the deal on the players, not on the gamblers, the latter whom he identified as Arnold Rothstein, Abe Attell, and a mysterious man known only by the name of Bennett, another of the go-between gamblers. The 8 players had agreed to throw the series for $100,000, according to Sleepy Bill. But all did not go according to plan. Burns testified that gambler Attell had been unable to get all the money and couldn't deliver the full amount they agreed to pay the players. Consequently, not all the members of the team who were expecting blood money got what they were promised. After throwing the first 2 games according to plan, Sleepy Bill Burns was unable to deliver the promised bribe to throw the rest of the games. Gambler Attell had paid only $10,000 to the players, which was first paid to pitcher Seacott. The players in on the scandal were angry that they hadn't been paid for the first 2 games and reneged on the original deal to throw the entire series. Sleepy Bill detailed the players' double cross of the gamblers.
Urged by the alleged fixers to win the third game to improve the betting odds, the players said they had lost for 2 regulars, Cincinnati and Williams, and would not win for Bush Leaguer Dick Kerr, the pitcher slated for the third game. Then, feeling they'd been crossed by the gamblers, they double-crossed their bribers by telling them they would lose the third game, but instead won it 3-0 with Dick Kerr pitching.
Sleepy Bill Burns' carefully scripted testimony was building.
His testimony, the most dramatic yet entered, was climaxed as he finished the details of the purchase and sale of a World Series by rising dramatically to his feet at the end of the day's session and pointing out one of the defendants as the mysterious Bennett, the alleged lieutenant of Arnold Rothstein, famed New York gangster and gambler, who, the state says, financed the whole conspiracy. Zelzer, another alleged gambler, was also named. All afternoon, Sleepy Bill Burns had spoken repeatedly of Bennett, the man who worked with Attell and Rothstein to frame the conspiracy.
Not only were the Black Sox on trial, but also the gamblers charged by the state, in the same trial. As with most criminal prosecutions, the prosecution was trying for guilt by association, the bad with the not so bad. By lumping the players together with the gamblers, the prosecution tactically tarred the Black Sox. On Sleepy Bill Burns' cross-examination, the defense lawyers went for the jugular. First up was attorney James Ropes O'Brien, famous for his red tie and for obtaining murder convictions. Ropes, who was so nicknamed for winning many death penalty cases as a prosecutor, opened the cross-examination.
You went to Mexico when you were indicted?
Yes.
Sleepy Bill Burns said he came back to the United States in April and met American League President Van Johnson on the border.
What were you doing in Texas where you were getting money from Johnson?
I was fishing.
What for? Witnesses?
Burns then told of coming to Chicago with Van Johnson to testify.
You knew you were under indictment when you came to Chicago?
Yes.
Being under indictment didn't worry you, did it, Burns?
No.
Ropes O'Brien slightly dented Burns' testimony, as paid for by Van Johnson, Comiskey's baseball rival. 6 defense attorneys on cross got Burns to admit only one mistake in his testimony, a mix-up about where he met the players, an inconsequential point. But Sleepy Bill Burns had a famous exchange with defense attorney Ben Short that confirmed who held the upper hand.
You don't like me much, do you, Bill?
Sure I do, Ben. You're a smart fellow. And I wish we had someone like you at the head of this deal. We'd all be rich now.
Some newspapers reported the back and forth as drawing first blood, but the exchange did little to damage Burns' testimony, and his sharp sarcasm even bolstered it. While the defense first got Burns to admit he enjoyed identifying Cincinnati as the lead schemer, he also admitted that he turned state's evidence because the players double-crossed him. Neither admission mattered. Sleepy Bill Burns stepped down with his testimony intact and relatively unscathed by the wolf pack of defense lawyers, as the newspapers called them. Of note, however, was what Burns did not say. He never mentioned the name Shoeless Joe Jackson. The following day, July 22, 1921, brought mostly circumstantial evidence, and it looked like the prosecution had fired its best ammunition with Burns' testimony. The prosecution next called the secretary of the Chicago Cubs, who confirmed that a New York gambling gang had bet on Cincinnati to win the series. The secretary also said he was a stakeholder of several bets made by gambler Abe Attell. This testimony succeeded only in showing that betting on games was rampant even among other teams, a point that benefited the defense rather than the prosecution. Offering the Cubs' secretary's testimony was the first fatal mistake for the prosecution. The prosecution continued to stumble with its next witness, Harry Redmond. Although his testimony certainly was sensational and high drama for a courtroom, it was yet another mistake for the state's attorneys to include it. While the testimony of Sleepy Bill Burns placed the source of the fix with pitcher Ed Cincinnati, Redmond contradicted that testimony, and as a newspaper reporter noted, The new accused person didn't fit the profile of a high-flying gambler capable of fixing the series.
The spotlight at the Black Sox trial was turned on a little red-headed chap named Carl Zork late Friday, and, at last account, Zork was still talking about it. Zork, it seems, is a gambler. At least the state, which has indicted him, so alleges. Yet a fellow townsman from St. Louis, Harry Redmond, a witness, created something of a sensation when, looking across at the little fellow peering around a pillar, declared, "He's the little redhead who started it all." Zork gasped. He appeared to wilt. All eyes were on him. Hitherto, he had been a lesser light in the proceedings. "Will the witness explain?" asked attorney Henry Berger. Redmond said that he was in Hotel Morrison, Chicago, after the third World Series game. He had a meeting in the grill room with Zork, Joe Pesch, also of St. Louis, and another tall man whom he didn't remember. "We talked for 3 hours, or at least Zork did. The rest of us talked for about 15 minutes, all told. Zork said to me, 'I'm the little redhead from St. Louis who started it all. I'm the man who fixed the series.' Redmond said he and Pesch turned down a proposition from Zork to chip in $5,000 into the pot to fix the ball players. Redmond, who said he was a motion picture theater owner, engaged in an acrimonious debate with attorney Berger, who accused him of being a bookmaker and a gambler. 'You lie!' shouted the witness. A verbal tete-a-tete ensued, the witness finally saying, 'You won't come outside and talk like that to me.'"
Berger's dispute with his own witness destroyed the believability of Redmond's testimony, if not defeated the prosecution's case outright. Even without putting on a defense, the case turned squarely in the defendant's favor with this single witness. The reporter continued.
Court then returned to normalcy, and the big battle over the admission of confessions of Eddie Cicotte, Joe Jackson, and Claude Williams, ballplayers, to the Cook County Grand Jury last fall was started. Judge Hugo Friend asked the jury to retire while Hartley Replogle, assistant state's attorney at the time the confessions were made, was being examined, the judge reserving his decision as to whether the jury could hear this evidence until Monday. Replogle said that Cicotte, Jackson, and Williams confessed to their part in the alleged conspiracy to throw the 1919 World Series without any pressure having been brought upon them by him. "Didn't you promise Cicotte he would be taken care of?" Attorney Daniel R. Cassidy, Cicotte's lawyer, demanded. "I did not," Replogle replied. "Didn't you and I talk of immunity to Cicotte?" "We certainly did not," answered Replogle hotly. Replogle testified that the confessions were purely voluntary, that he told all three that their admissions might be used against them at a future trial, and that the trio signed immunity waivers in his presence. The defense let it be known that the three ball players would be put on the stand to refute Replogle's testimony.
If the player and attorney had in fact talked about immunity, then it should have been written down in a confession, or at least in another document signed off by both attorney Replogle and the players. To have failed to document such an important point raises at least the bare question whether the agreement was made in the first place, a point not lost on the judge. After listening to the testimony of the three players and the judge who presided over the grand jury proceedings where the confessions were given, Judge Friend decided to admit the confessions, but only against the individuals who gave them, not the full set of players. Attorney Replogle would be the prosecution's next to final witness as the state prepared to rest its case. The court resumed on Tuesday, July 26, 1921. The court, without the jury, first heard the confessions of the three ball players to determine whether they were voluntary. Eddie Cicotte took the stand first.
Attorneys Austrian and Replogle told me to come clean and tell what I knew, and they would free me. They said to me, "This is going to be a long trial. You don't want your wife and babies to suffer while you're in the penitentiary, do you?" I confessed, and when I was in the grand jury room, Judge McDonald said, "Go ahead and indict him." I protested and said I had been promised freedom. The judge shouted, "What are you trying to do? Bullshit me?" They asked me to step out of the room, and when I came back, I was indicted.
Isn't it a fact you signed an immunity waiver?
I signed something. I don't know what it was.
Shoeless Joe next took the stand.
Judge Austrian asked me if I knew I would be indicted. I told him I didn't know about it. Austrian then asked if I had a lawyer. I told him I did not. Austrian then shouted, "You better get one! You need a lawyer damned bad!" I then was taken over where the grand jury was in session. On the way over with Attorney Replogle, he told me Cincott was a free man. I was told the gamblers and not the ball players were the ones the law wanted. They told me to tell my story and I would be free. They said I could go anywhere I wanted to afterwards, to the South Sea Islands if I wanted to.
What happened then?
I left the court in the company of 2 bailiffs. I took them out and got them drunk that night. I thought I was free.
The prosecution won their motion to admit into evidence the 3 confessions of the ball players given to the grand jury. After hearing the testimony of the players about the manner the confessions were given, Judge Friend ruled they were made voluntarily and allowed them into evidence. Given that the trio's original confessions had mysteriously disappeared from the state's files, the prosecution read the confessions into evidence from stenographic notes taken at the time the confessions were made. The ultimate victory for the prosecutors, however, would have been to force the players to read their own confessions to the jury, rather than the lawyers reading them from notes. Either the prosecution didn't think of it, or the judge wouldn't allow it, but they lost an opportunity to present the evidence in the most damning fashion. The prosecution first read Lefty Williams's confession, then Shoeless Joe Jackson's 29-page long-winded confession came next. It damned the left fielder. Jackson admitted to taking the bribe, but claimed not to have thrown any of the games and played his hardest. Finally, the prosecutors read Cincott's confession, just as damning as the previous 2. A year earlier, on September 28, 1920, Eddie Cincott admitted he helped fix the World Series. That admission was taken at the law office of Alfred Austrian, who was both legal counsel for the White Sox and who worked with Rothstein. Once he admitted his role in the fix, Eddie was quickly escorted to the criminal courts building, where Assistant State Attorney Hartley Replogle questioned Eddie in front of Judge Charles McDonald and the grand jury. The court reporter at the time took down Eddie's confession.
I don't know why I did it. I must have been crazy. Risberg, Gandil, and McMullen were at me for a week before the series began. They wanted me to go crooked. Then Gandil and McMullen took us all one by one away from the others, and we talked turkey. Gandil asked me my price. I told him $10,000, and I told him $10,000 was to be paid in advance. It was Gandil I was talking to. He wanted to give me some money at the time, the rest after the games were played and lost. But it didn't go with me. Well, the argument went on for days. The argument for some now, some later. But I stood pat. I wanted that $10,000, and I got it.
The bombshells had been dropped on the players in the most devastating way. In baseball terms, it looked like the players were down by 1 in the bottom of the 9th, bases loaded, full count, but they had been thrown out at the plate to lose the game. Things looked bleak for the players. After one final witness confirmed Sleepy Bill Burns' testimony, the prosecution closed its case. When the prosecution rests, the defense typically makes a motion for a non-suit, seeking to dismiss the charges against the defendants for lack of evidence. The lawyers for the players and the gamblers made those motions, which got a mixed reception.
Evidence introduced against players Buck Weaver and Happy Felsch did not warrant sending their case to the jury, Judge Friend held, and announced he would dismiss the charges against the 2. The state offered no objection. The case of Carl Zork and Louis Levi, 2 of the alleged low-level gamblers, were also to be dismissed, the court ruled, because of lack of evidence.
During the course of defending this case, the remaining defense attorneys had to choose whether the 6 players left or the gamblers would take the opening gambit. Given that the charges against the gamblers hinged on whether the players threw the game, it would seem to favor the players going first. But there's always the aspect of building toward a dramatic finish. The players wanted the cleanup position. Accused gambler David Zelzer went first for the defense.
I was never in New York, except in 1917. I never met Burns or Maharg in Cincinnati. I never saw either of them until they testified here. I do not know any of the defendant players. I never saw any of them except on a ball field until I came here for this trial.
When the time came for the players' lawyers to put on their side of the case, their first tactic was to attack the state's argument that the players did not play to the best of their ability. The lawyers put on 2 teammates and 1 opponent as expert witnesses, but failed to admit their testimony into evidence.
Baseball players John Collins and Nemo Leibold, who were with the White Sox during the alleged crooked series, were asked to testify if they believe the indicted men played to the best of their ability. Question after question was put to the 2 witnesses by Ropes O'Brien and Thomas Nash, defense attorneys, with the hope of bringing out this point. Every question was objected to by the state and upheld by the court. The witnesses were excused without being able to testify, as they apparently were ready to do, that the Black Sox played to the best of their ability. The court would not let Dutch Ruther, who played with the Cincinnati Reds during the disputed series, state his opinions as to whether the Black Sox played to the best of their ability.
The state's objections were likely based on foundation and relevance, which refers to the ability of those players to accurately testify about how the Black Sox played. The state must have also argued that these players had no ability to tell whether the errors were intentional, which were the ultimate facts that the jury were to determine, a point judges will not allow experts to testify about. Nonetheless, the defense had made their point to the jurors. If their teammates and opponents were willing to testify for the Black Sox, then they must not be guilty. Part of the alleged con by the Black Sox was based on their intent to deprive the White Sox owner Old Roman Comiskey of his profits, so the defense lawyers next called the team's secretary to examine him on the issue of those profits.
Team records showed the fans paid out $910,000 to see the White Sox perform in 1920. This sum represents the gate receipts at home and the share of receipts while the team was abroad. The White Sox club took in $521,000 in 1919, exclusive of the World Series share, which brought the total gross receipts up to $608,000. A profit of $226,000 was made in 1920 and $107,000 in 1919. It was revealed under cross-examination that Comiskey was paid $50,000 in salary by the Sox company last year in addition to his profits.
These high dollar amounts overwhelmed the working-class blue-collar men on the jury even more than the players' salaries. The defense tactic was to show Comiskey's greed. When the jurors heard how much Comiskey made when compared to his players, the defense had driven one more nail into the coffin that sealed shut the prosecution's case. The defense lawyers wisely chose to rest their case with the end of the secretary's testimony. Court recessed for the evening, with closing arguments slated to start on Friday, July 29, 1921. In closing, the prosecution argued what was expected. The players had confessed to the scheme and were guilty as charged. The defense likewise performed as expected, blaming just about everyone else involved. Comiskey, Sleepy Bill Burns, Rothstein, and even Rothstein's lawyers, Alfred Austrian and William Fallon. They attacked the prosecution's case, claiming the state's attorneys had not proven fraud, instead arguing that the boys had played their hearts out in the World Series and lost the championship fair and square. Judge Friend instructed the jury to consider the evidence and the arguments of the attorneys. The jury deliberated for just 2 hours and 47 minutes and found the 8 men and 2 gamblers not guilty on August 2nd, 1921. When the foreman announced the 8 separate verdicts for the players, cries of jubilation erupted. The jurors spilled from the bleachers in the jury box, grabbed the boys, and threw them up on their shoulders, parading them around the courtroom. Each of the jurors had signed each of the 8 not guilty verdicts. Newspapermen rushed to their typewriters, and the next day, the newspapers plastered the verdict across their front pages.
The verdict from Chicago being shouted across the nation today. Not guilty for the 7 former Chicago White Sox players and 2 others on trial for the alleged conspiracy to defraud the public through throwing of the 1919 World Series. After the verdict was read, pandemonium reigned in the courtroom as the accused men went wild with joy, and the spectators in the room joined in.
The headlines may have screamed vindication in court, but Major League Baseball's head commissioner, Kennesaw Landis, would have none of it. He banned the players for life as of August 4th, 1921, just 2 days after their favorable court decision. The commissioner issued a statement.
Regardless of the verdicts of juries, no player who throws a ball game, no player that undertakes or promises to throw a ball game, no player that sits in conference with a bunch of crooked players and gamblers where the ways and means of throwing a game are discussed, it does not properly tell his club about it, will ever play professional baseball. Just keep it in mind that regardless of the verdict of juries, baseball is entirely competent to protect itself against crooks both inside and outside the game.
The 8 Chicago players never played Major League Baseball again. How the jury could have reached these acquittals is astounding, especially in light of the players' confessions. The players' status undoubtedly swayed the jury, and perhaps the sniping between the prosecution and defense attorneys didn't help either, with the jury obviously taking the defense's side. The prosecution's choice to try the gamblers with the players added a significant twist and ultimately hurt the prosecution's case. The jury did not want to paint the players with the same brush as the gamblers. Had the prosecution separately tried the players from the gamblers, the state's attorneys might have been able to obtain convictions, at least against the gamblers. But ultimately, because of the control Major League Baseball had on the players' ability to remain on its teams, their not guilty verdicts mattered little to the game itself. Perhaps Commissioner Landis wanted both their convictions and their lifetime suspensions to restore baseball's reputation. But without the convictions, his banishment remedy alone was left to heal baseball's black eye. Commissioner Landis's lifetime bans attempted to convince the American public that the game was as trustworthy as Grandma's apple pie. But at the time, that was a perception quite distant from the truth. Thank you for joining us today. I hope you enjoyed this story. This episode is adapted from a chapter in my book, which is now available for purchase. So if you want the full story of the Black Sox trial and the other 9 trials covered in my book, please pick up a copy and learn all the details, testimony, and juicy bits that didn't make these episodes. You can buy copies on Amazon and from all major booksellers. The book, How Would You Decide? 10 Famous Trials That Changed History, is published by Crimson Cloak Publishing, and I'm its author, J. Craig Williams. Thanks go to our scriptwriter, sound designer, and sound mixer, Nathan Todd Hunter, our producer, Kate Kenny, Lisa Kirkman, our director of partnerships, and the publisher of my book, Carly McCracken of Crimson Cloak Publishing, who granted permission for Legal Talk Network's adaptation. Special thanks go to our voiceover actors, Brandon Harphold, who played the role of Shoeless Joe Jackson, Todd Berger, who played the role of Eddie Seacott, Tom Mile, who played the role of Al Spink, Dennis Kennedy, who played the role of David Zelzer, Chad Trudeau, who played the role of James Ropes O'Brien, Alan Chudnow, who played the role of Sleepy Bill Burns, Adam Lockwood, who played the role of Carl Victor Little, Jim Brady, who played the role of Commissioner Landis, Lily Spader and Nathan Todd Hunter, who played the roles of the newspaper journalists, and Thomas Wolfe and Kerry Lockwood, who played the role of the radio broadcasters. In the next episode, we'll examine the 1925 Scopes monkey trial, which pitted evolution versus creationism. Thanks for the privilege of your time today. We look forward to seeing you again. I'm Craig Williams. Please stay tuned for our next episode of In Dispute on the Legal Talk Network.